it's this legal arrangement where a grantor, which is the person who set up and established and maybe funded the trust, is giving the trustee control of certain assets, and they're supposed to be managed this way for future beneficiaries. That's simply put all it is. Welcome to a Wiser Retirement Podcast. Are you curious about the best way to use trusts? I'm Shawna Theriault, and today I'm joined by estate planning attorney Arun Gupta. Each week, we bring you practical advice on retirement, investing, and planning for your financial future. Don't forget to subscribe to the podcast wherever you're listening. Let's get started.
All right.
Good morning.
Good morning.
Good to see you.
Good to see you too,
Always
Shawna.
good to see you.
Yes.
It's a really heavy subject for early in the morning, isn't it?
Yes and no.
Well, I know we get asked about trusts all the time, and obviously that's your specialty and looking at it. And so we just thought it would be good to bring you on and talk about 10 different types of trusts today and just go through them. And now all of these, you and I have talked a little bit, all of these are not everyday trusts that everyone would use.
Sure.
But, if you've heard the term, it's kind of like, well, what is that if you're curious about what it is? And, so it's trusts are important. What is a trust actually? I looked up like the definition, and it would probably be better coming from you, but.
Yeah, so I think of it as, and some of these, the terms in and of itself are confusing, but it's a legal document where someone, the grantor, they should be funding a trust, and within the four corners of the trust, it's almost like you can think of it like a contract. This is how the trust is supposed to be distributed for a beneficiary.
Yeah.
Sometimes that beneficiary can be the grantor of the trust. Most people wouldn't think of it like that, but that's what a trust is, and I'm sure people will often get some terms confused, and as they should, because this stuff is tricky. Revocable trust, living trust, irrevocable trust, and then there's a million different types of trusts that have acronyms that are, tough for anyone to keep up with. So it is confusing. However, the concept of a trust is not something for super wealthy people or anything like that.
Yeah.
They are practical. And your life situation is going to dictate whether a trust, is right for you. And it certainly shouldn't be dictated by, I don't have enough money to do this.
Right.
That's not what it's about.
Well, right. Because sometimes it's just the way you transfer property.
Yeah.
And so, the trust being, it's this legal arrangement where a grantor, which is the person who set up and established and maybe funded the trust, is giving the trustee control of certain assets, and they're supposed to be managed this way for future beneficiaries.
Yes.
That's simply put all it is.
Yeah.
And so if you have a situation, it's like, okay, this is where I like to what is the end in mind? Here's my situation. Here's what I'm trying to do. How do we solve for that? Sometimes trusts are appropriate and sometimes they're not.
Yes.
And so there's all those different kinds of what you're trying to do. There's all these different types to choose from that we can use as tools.
Yes.
And so that's like the whole premise. But you should always use an attorney in this, just because, such as yourself, is because it is confusing. I mean, even us where we have, 25 plus years as advisors, we always consult attorneys, with all of this. It's very important.
Yes. And, there's a lot of do-it-yourself trusts out there. And, while there are benefits, they can at least get you started. It never ends with the trust. The trust at the end of the day is it's their words, right? There's many steps involved after that. Funding a trust, making sure you review your estate plan consistently. Life situations are going to dictate, how, these trusts should be used.
Right.
There are times where you set up a trust and you don't even need it later down the road. These are things that should be, revisited often.
Absolutely. So we're going to go through 10 different types of trusts, and this is not all there's more trust than what we're going through. And a couple of these are, they're kind of key buzzwords that people have asked about, but some of them, are not used regularly, but at least we can touch on what are they, et cetera. And so we're going to go through 10 different types of trusts, and, some will go more into more detail just because they're more
practical.
And they're used more widely by people, by clients, and some will just touch on. But that way you can kind of go through each one and say, okay, at least you have a somewhat understanding. And we're gonna try to not make this too convoluted, but some of them are confusing. So we'll some of them will just be brief and highlight. But starting with, we'll go through maybe who it's appropriate for. So starting with a revocable living trust. So
yes, that is the most common type of trust. It is the document that I probably draft the most. People will often ask, do I need a trust or a will? And what they really are getting at is, do I need a revocable trust or can I get by with a will? And again, it's always going to depend on your life circumstances, but more often than not, my clients prefer to use revocable trusts as their main estate planning vehicle. And a revocable trust is the situation where the grantor, for example, me, I would create a trust. The grantor is also the trustee of the trust. The trustee is the person that's the point person for the trust. They're the ones that are signing the checks, making sure that assets are distributed pursuant to the terms of the trust. The main difference, and a very important difference between revocable trusts and irrevocable trusts, and most of the other trusts that we're going to talk about are irrevocable trusts, but it is flexibility. You can amend a trust basically whenever you want, as long as you still have capacity. You can change the terms very easily through a simple amendment, or if you want to, change many things, sometimes it's easier to just do a restatement of that trust where you're basically republishing it. But the intro provisions for a trust are pretty basic. It is anything that is titled under this trust is to be used for my benefit for the rest of my life, and I can control it just as I would in my own individual account.
Yeah, and exactly. That's so really. The first two were revocable and irrevocable trust, which, a trust is either revocable, meaning you can change it.
Yes.
Or it's irrevocable, meaning you cannot change it.
Yes.
Right. And so that's kind of, I don't know if that's a specific trust, but it's also it's also a function of the trust. And so what I like to say, how I explain it to clients is, okay, think of a revocable living trust as an extension of yourself.
Exactly. I use that phrase all the time.
Yeah. It's still your social security number. Everything is filed on your personal tax return as if it was you. It's just a means for putting it in the trust for ease of transfer or administration later, potentially. Is that fair?
That's right. Because a revocable trust, as soon as you die or the surviving spouse dies, if it's a joint trust, but when that happens, it's not a revocable trust anymore.
Right.
It is at that point the terms cannot be changed, and it is its own entity. And that's really the biggest difference between a revocable trust and all of the other trusts that we're gonna talk about today.
Because all the other trusts are irrevocable, which means it cannot be changed.
Yes.
And if it's fair to say, if I may, an irrevocable trust, think of it as its own entity, as its own. It's not a person, but it's a separate entity that files its own tax return.
Generally speaking,
but some of them don't.
Some of them don't.
Okay.
Yeah, some irrevocable trusts they'll file a tax return. The trust will file a tax return.
Right.
I mean, the trustee is still the person that's signing it, but there are certain types of trust that are called grantor trusts, where basically the person that is the grantor of the trust, they're still responsible for the tax consequences go to them. And you brought up the irrevocable trust cannot be changed. Yes, generally speaking, they can't, especially over the last few years. A lot of states, Georgia too, you can modify irrevocable trusts. You can either go through court, which is way more expensive and time consuming, but you can have non-judicial settlement agreements that can actually change the terms of a trust. However, it's not that easy. You'll have to have many people sign off on it. I don't want to tell a client that, hey, you're going to, if this needs to be changed later, you can do it. I mean, technically speaking, yes, but that's not how you want to think
enter
about it.
The contract or the legal arrangement.
Exactly.
You should think of it as it's irrevocable. It can't be changed.
Control is the big thing. Once it's in an irrevocable trust, you lose control over it.
Because you just have to follow what the trust says.
Yes. And if you don't, and things must be changed for whatever reason, sometimes it's going to make sense to go through these other avenues to alter or amend the terms of that trust. But it's a chore and it's a headache.
Well, and to just extend on that, and again, this is the first two we're talking about, irrevocable versus revocable. And a lot of trusts in and of itself can just be irrevocable. It's just a type of whether you can change it or not. But the whole purpose of doing an irrevocable trust is so that it can't be changed. And so here's what I want, and I don't want it to be changed. Yes. And so, there are times where, situations may evolve over time where you're like, ooh, I didn't want to do it like that. Mm-hmm. So maybe that's where you're talking about,
Yes.
But you wouldn't enter into it thinking, oh, I can just change it later.
Exactly. You want to think of it. And what I'll tell clients too is, once it's in there, okay, once it's not yours anymore. It is the trust's. That you are not the trust. A lot of these are designed for tax purposes. At the end of the day, there are many of these that we'll get into. There's tax benefits, and that's why people give up control of it. So there's a better tax benefit either for themselves or when they pass away for their loved ones and their beneficiaries.
Yeah.
And they can be very useful tools.
Or family protection or creditor protection.
Exactly.
Because it's a separate entity. I don't own this. It's not mine. Versus like a revocable living trust.
Yes.
I've heard some people say, I want to protect myself from creditors. I want to put in a revocable living trust. Mm-hmm. Well, that doesn't do that.
That's a very, very common thing that
that's a misconception.
It's a misconception because, the main benefit of a revocable trust is in my opinion, is the avoidance of a probate proceeding at death. So any assets that are titled under a revocable trust while you're alive, or that name the trust as a beneficiary or some other beneficiaries, those are going to be distributed pursuant to the terms of the trust. You don't have to get a probate certificate you don't have to have an executor appointed by a court in order to transfer those assets. That's the biggest benefit of a revocable trust, in my opinion, probate avoidance. But
it just expedites the process too, and it just makes it simpler.
Yes, but people will say, oh well, I want to put my home in a trust, so I get asset protection. No, that's not gonna help you liability wise. If you have a rental property and your revocable trust owns it, and there's a slip and fall on that property, it's not like an LLC.
Right.
It's a revocable trust. It's taxed at your own Social Security. It's an extension of you. It's not a separate legal entity that is separate from you. You're still connected to it as long as you're alive and you can amend the terms of the trust. That's part of the reason why it's in that category. You can put your home in an irrevocable trust. I caution people against that. Especially their personal residence, because again, once it's in there, all right, to unwind that is tough, and it can
doesn't it get into gifting issues and stuff too.
There's that.
That's very complex, obviously.
Yes, and mortgage issues with your lender. It can create a headache, and before you do it, now you can do it, but before that actually happens, as long as you've got the information. That then you can make a much more educated decision.
But you may not even need to do that. If you're doing it for liability, there's other ways to do it that are cleaner.
Yes, exactly.
So,
a simple LLC. If it's a rental property, I usually will suggest if you're looking for asset protection, an LLC is the way to go. But that's going to be separate from a trust. There are other trusts here that will offer asset protection for a property that you own there, or any other asset that you own. But generally speaking. A revocable trust, that's not what you're getting when you do that. That is more probate avoidance and making sure that there's a level of privacy that is offered with the revocable trusts. I'll just give you an example. Let's say that you have 3 kids, and one of your kids, for whatever reason it happens, but you have a falling out. You want to disinherit your kid. If you have your will is your main estate planning vehicle in Georgia. When it's time to probate, even though you disinherited your child, they're still going to be served with a copy of the will when you're petitioning the court to probate it, even though they're not named, and they are asked to sign an acknowledgement that this is a correct copy of the will as far as I know, and I'm okay with this executor being appointed. But hey, when there's a if you disinherited them, there's probably a reason for it. And if they want to, cause problems, they can. If you used a trust as your main estate planning vehicle and no probate is required, they don't have to be served with a copy of the will. They don't have to.
They don't get a copy of the trust either.
They don't have to.
It just passes by who gets.
They don't. Yeah, they're not required to.
I didn't know that.
So that's.
I learn something new from you every day.
That's a practical benefit that I've seen. With the revocable trust versus a will, but
So family issues, maybe do a revocable living trust to kind of like.
Yes.
Okay.
Yes, for sure. Probate avoidance, privacy, family issues, ease of administration. Those are the key benefits. And a con of a trust, and I say it's a con because I don't, in my experience, especially over the past few years, as I've used trusts more, once you sign the trust, that's the step one. There's a step two that is daunting for people, and that is funding your trust, retitling assets to the trust, or naming your trust as a payable on death beneficiary. It's a lot if you've got assets in a lot of places.
That's a great point, because if you set up a trust and here's this paper document, but nothing's in it and you didn't do anything with it,
you're losing the whole point of it. Yep.
Yeah.
And it's work to do that, but it's not complicated work. It's in a sense basic form filling, or and that's why I think it's important for your attorney to have a relationship with your financial advisor, with your accountant, to make sure everyone's on the same page about this, to make your life easier. And once the admin work of retitling assets to the trust or naming the trust as a beneficiary, once all that's done, in my opinion, it's actually easier to administer going forward, because when you amend the trust down the line, if you've already retitled assets or already put your trust as a beneficiary, it's going to capture any amendment you make.
So like once you sign it, it's already updated, essentially, because it's just referencing the trust.
Yes. Now, maybe you don't want all assets to flow in the same manner as your trust. So regardless, it's always a good idea to, check in with your estate plan every few years, no matter what. But the daunting aspects of it, to me, it's a one time. If you do it right, it's just the initial headache of it that, again, it's form filling, in my opinion. Now, some of these other trusts, the admin part is not, you can't just snap your fingers or fill out a form. It is heavy tax reporting. It is you got to be real careful with a lot of these things to make sure that you're not skirting the system, and you're not just doing something to not pay taxes. Where in reality, I totally understand. That's the main reason why a lot of people use a lot of the irrevocable trusts that we're going to mention is taxes, and that's okay. But
you have to do them properly to make sure you don't get taxed.
You have to do them properly, and the IRS. If you say, well, the whole point of me doing this is just to not pay taxes, you can't do that.
No.
However, these are designed. The tax rules are if you follow them, you're going to be okay. But following them is important.
Well, let's get into just a few of these. So we went over revocable living trust and what an irrevocable trust is. Testamentary trust.
Yes. So a testamentary trust is a trust that's created under a will. So if I have a will as my estate planning vehicle, and I say at my death, I want my assets to be held in trust for my children. That's a testamentary trust.
Which is very common. That's a very common language.
Very, very common, because it's a trust that was created under your last will and testament. That's what a testamentary trust is.
And technically, it doesn't exist until you die, and that's what triggers it. So the date of the trust is your date of death.
Correct.
Right? And so that's when it's actually formed. So it's referenced in your will, but it's not even alive yet. It's not created until you pass away.
Exactly. It holds no real, you can't use it as collateral, for example. You can't say, oh, well, my parents set up a trust under the will, and it's not yours. They haven't died, and this trust is not funded.
Right.
It's words on paper, until there's an actual event.
And technically, they could always change the will,
and they can always change it. Yes,
exactly.
And that's another reason why you can't use it, as collateral.
So that is just simply a trust that is created in your will when you pass away, often used for minor children.
Yes.
And then it would have a separate tax ID.
Yes.
It is irrevocable in nature. It cannot be changed.
Yes.
And then whatever's referenced in the will and talking about how that trust functions, that's the trust document.
That is yes.
And then it sets up a separate tax ID, files its own tax return, has a separate account.
Yep.
And then this is how it's administered, and it names a trustee, et cetera.
Yep, exactly.
Okay. So that's a testamentary trust, which is very common, that is referenced in your will.
Yep.
Okay. So the next trust we're going to talk about is a charitable remainder trust.
Yes.
Okay.
So a charitable remainder trust, it basically is a document where you name it, combines charitable giving and tax benefits. Basically, you are getting you set up a trust where you get a fixed percentage of what you funded with the trust, let's say 5% each year. And then, at your death, the remaining trust assets will either go to charities or beneficiaries, and then charities. And the main point, or not the main point, but one of the benefits of it is you get an immediate tax deduction, because it's calculated based on, hey, the charity is going to get something, so you're going to get a tax benefit, but it has to be funded. The trust has to, actually exist with assets for you to actually, get that tax benefit.
So basically, you set up a trust, you put assets in there, you get a tax deduction for future value that's going to the trust, to the charity, but you get an income stream from it.
You're still,
and then it's out of your estate for estate tax calculations.
Correct.
So you basically, you lose control of this. It is now in a trust. You can get income
You're
from it.
You're getting the income. Yep.
But then it's going to charity. So this would be good for, families that are philanthropic potentially, that have a lot of assets that they're not going to use during their lifetime, that they're eventually going to give to a charity, potentially.
I think it's a good way to combo charitable giving and getting an immediate tax deduction. And getting an income stream.
So it's not like you're just giving to a charity now getting tax deduction. You don't get anything from it. You get income from it, so you can have an income source during your lifetime. And then if you pass, maybe to family for a little while, but then eventually it goes to So it's a way to give assets, get an income from it, get a charitable deduction, and then it's out of your estate.
But it also requires there's administration, right? Each year, you can't set it and forget it, right? There's it's at least annually, it's going to require, attention.
Quick check-in. Have you thought about the legacy you'll leave behind? Download 7 Steps to Leave a Financial Legacy, a free guide from Wiser Wealth Management to learn more. It's not just about wealth. It's about leaving a lasting impact. Go to wiserinvestor.com/guides to download your free guide today. Now let's jump back into the episode.
So these are the CRATs and the CRUTs, that if you've heard of those, and they're all part of a charitable remainder trust. One has like a fixed dollar amount annually that you get. One is a percentage that you get. But there's certain parameters, administration, you said, obviously, that you have to do during the year. It files a separate tax return. It has to, you have to calculate certain distributions to make sure that you're taking out enough, because there's a minimum. You have to take out at least 5% a year.
Yes.
So, in order for it to stay and still be called this type of trust.
Correct. Yes.
So there's certain IRS regulations you have to follow. So that takes administration and work.
So, there's the immediate tax benefit, an possible estate tax benefit, and giving to charity. But the con, I would say, is you're giving up control, and it's constant administration.
And then the assets are not going to go to the family in the end, obviously.
Yes,
so,
it's correct.
So that's, it's like some clients are like, well, I want to save money and I want to save taxes, or I want to, et cetera. But it's like, okay, even if you're, and I'm not saying you shouldn't be philanthropic, please hear my heart on that. I'm saying, but it's like, it's like, okay, I could give to charity and get a deduction, but I'm like, yes, but it's still reducing your estate, and it's still going outside of the family.
Of course.
Which, if that's your intent, great. And I'm not saying we shouldn't be philanthropic, obviously, but just know that if you're doing this for a tax benefit, you're also reducing overall what you're passing to your heirs.
Correct. You are.
So, it's like that just has to be considered.
For sure.
And a lot of time, if you're if your kids are well off, or there's the estate's large enough that there is enough, and this is, you're philanthropic, it may be just a good option.
I agree.
So the next kind of trust is a special needs trust.
Yes. So a special needs trust is designed for assets to be, in a trust, protected, and to provide for a special needs beneficiary. Now, that definition there's a lot that goes into it, but in a nutshell, the idea of it is to provide for a special needs beneficiary, but at the same time, not having the value of those assets negatively affect the benefits that they would otherwise be receiving from the government.
Right.
So in a simple way to put it is basically, that's not their asset, that's the trust's asset. Even though they are the beneficiary, they don't have control over it. So it's not theirs, and it's going to affect if you just gave that asset to the beneficiary or put it in some other sort of vehicle, you may not be able to exclude those from the assets that you have to report to qualify for certain benefits that you receive.
Right. So in other words, if I were just to leave this money outright to my child who is special needs, even a grown child, and they're getting state benefits, and anyone who has, well, I don't want to say that, but many people who have special needs in their family, they understand the income and the assets and the calculations that go into that. And if you don't, we have people that can help with that. But, it's, if you just give the assets outright to them, then they're going to have to use those assets first before they can get benefits. And so it's a nice complement to, they have the access to this. The trustee controls it. They can get money from it. It's not in their control, but they can still also get the benefits.
That's right. That's right. And these trusts can be set up while you're alive. You can say, I'm setting up a special needs trust now, and I'm going to fund it for my special needs child or other beneficiary. And it's called that's a third party special needs trust where someone else is funding it. But if you can also, if you are a special needs person, you can create a first party special needs trust where your income is, your assets are going into this trust. But usually, more often than not in my practice, they are trusts created after someone dies.
In their
they
will.
Want it, in their will or their trust.
Revocable
trust to ensure that, hey, when I pass away, I want to make sure that my special needs beneficiary is receiving the maximum amount that they can be from both, the assets that I've contributed and from the government.
Well, and you just made me think of something too. In all of these trusts, it's like, okay, sometimes we don't fund them until we pass away because, what we've been talking about is if you created it now and funded it and you ended up needed access to that, it's gone.
Yeah, it's
so it's
there.
very convoluted or complicated to access. And so that's the point of putting it in, when I pass, then this happens.
Yes. And I'll tell clients sometimes also, listen, if you're unsure about whether to create this now or create it after your death, if you want, you can create it now. You don't have to fund it completely right now. You don't even have to, you can fund it down the road. You may not even fund it, right? But,
right.
And then, under your estate planning documents, you can say, when I die, this share to that beneficiary is going into their already existing special needs trust that I've already created. If I haven't, well, here's a new one.
Then it sets it up.
Yes.
Okay, perfect. The next one, I've been hearing a lot about this recently, actually. We added this in, the SLAT.
Yes.
We have all these acronyms. It's hilarious. SLAT, which is?
It's a spousal limited access trust. Basically, it's a way, in my opinion, it's to protect against estate taxes, and it's a way to maximize gifting. Basically, you can create a trust for the benefit of your spouse. You designate a trustee. That trust is to be used for that spouse's health, education, maintenance, and support until, for the rest of their life. And then when they pass away, it's, distributed to whatever beneficiaries you have listed in there. Once you fund this trust with an asset, it is removed from your taxable estate. So
you as the grantor?
Yes.
But is it still in your spouse's estate?
No, it's in its separate it's in a separate entity.
Okay.
Yes. And then it can grow estate tax free, because once it's out of your estate, it's no longer yours. Now, sometimes
all I can hear is like divorce.
Yeah, I
what if we get
exactly.
divorced? Oh,
so
now you got this trust set up, and it's for the benefit of my spouse that I'm divorcing.
Usually, there's built-in provisions that address those, but
Okay, good.
obviously, it's going to be an issue, right? And then there's also, well, some spouses would say, well, why don't we just set up 2 of these? I'll do one for you, and you do one for me, and I'll be the trustee of yours, and you when we do the same, the IRS will say you can't have mirror spousal. Well, so change it here, change it. There's a lot of these are gray areas, but usually it's an estate tax tool. Now,
so really, we want to look at these if we have large estates.
Yes, and I want to back up for a second here, and because we've been using the term estate tax a lot here. So right now, the estate tax exemption in the year 2025, if you die, you as an individual, you can pass a maximum of $14 million without your estate being subject to a tax per person, and anything over that amount is taxed at 40%. The estate would have to, within 9 months of your death, there would be an estate tax that would be owed. Now, 14 million is a lot bigger than what most people have, and it's been going up and up and up and up basically for the last 20, 25 years.
Right.
And 25 years ago, I think the exemption was $675,000. That's a completely different ballgame here. So a lot of these trusts that we're talking about right now, they're more relevant when the exemption is lower. That's not to dismiss them.
Which they can change it in the future, but they haven't been going down. Right.
I tell clients, listen, I can advise you as to what the law is right now, what is projected to be on the books, but I'm not going to sit here and tell you this is how it's going to be forever. Congress can change their minds whenever they want. Now, I don't think they will for a while, especially that's what the trend is, but I don't know what this world is going to be like in 10 years. I mean, you go back 10 years and you were to tell people this is the landscape of the political world, they would be shocked.
Right. Right.
So, these are good tool. Having the information is the most important part. And then you can see whether it's right for you.
Right. So, I mean, I think with that would be something, a lot of these special needs trusts, no, I mean, that's not necessarily for anybody over the exemption. That's just if you're protecting benefit, but something like a SLAT, that's like, I need to get assets out of my estate, let it grow out of my estate because I have large assets or assets that are going to grow. Yeah. Maybe you're going to get future inheritances. Mm-hmm. There's other things to take into consideration. Yes. Just for, the average, probably not needed to be used for that.
Yes.
So we hear this a lot and ask about it a lot. The generation skipping trust, what it is and what it's for. So
that figure that I said, the $14 million figure right now. So there's another tax. It's called the generation skipping transfer tax. If you give a grandchild, for example,
and you're skipping over their
you're basically
parent.
Skipping over their parent. Maybe your idea is, hey, listen, if I give it to them, then my kid's not going to have to pay. It's because I'm skipping them right now. Well, the government.
Right. So if your child, let's say your child is already very well financially endowed, you're like, okay, then I won't give them my assets, which then further messes up their estate tax problem, if you will. And so I'm going to skip them and go to my grandchild.
Yes, but you can't do that. Well, there's a certain, now the exemption is unified. Basically, you've got the same amount is exempt from this generation skipping transfer tax. If you give something to someone that is 2 generations younger than you, or I think it's 26 and a half years younger than you, that is considered a skip. A skip. So, and a lot of trusts have built in GST tax provisions in there that give the trustee the authority to split a trust from a GST exempt to non-exempt. I know this gets a little heavy on the terms, but they're tools to explore in order to save taxes.
So there is a trust that you can set up to be able to preserve wealth across multiple generations, and it may have the language that allows it. It doesn't come into play with the
language has to be there, right? If you give a child the authority to pay off their creditors or give it to then it's not going to be exempt, right? So all of the fine language needs to be in there.
So just know that if you're giving substantial assets or wanting to give substantial assets to a grandchild, then maybe you need to look at this option potentially,
Sure.
or just
Yes.
talk to an attorney about it.
Yeah, I talk
they
to
would
it.
bring
Yes,
it up,
exactly.
probably.
I would. Yes, exactly. I think they can be tools that you can use, but having the knowledge is the key to all of this and understanding it.
So the next one is Qualified Personal Residence Trust, which is CUPRT. That's
CUPRT,
what we call it, a CUPRT,
Yes.
QPRT.
Yes. So these are trusts. Let's say you have a vacation home. You can gift your vacation home to this trust, and the gift that you give, let's say it's a $1 million vacation home that you have, and you gift it to this trust. Even though you gave $1 million gift, okay, the trust is going to say it's going to be for a term, and then at the end of the term, the home is going to be owned by the beneficiaries. Let's say your children. Let's say it's a 20-year term. You've given a $1 million gift to the
Trust.
to the trust. However, for IRS purposes, that gift is going to be heavily discounted because you have given up control over. There's certain market. You've given up certain things to reduce the value of that. So, for example, let's just say the IRS with these formulas, you'll report it as a $500,000 gift. So really, you've given $1 million gift, but it's only reported at $500,000.
Meaning on your gift tax return,
On your
that
gift
then
tax
reduces, this is very complex. You have $14 million today that you can pass estate tax free. You just reduced it by $500,000.
13.5, but really you gave $1 million asset away,
Right.
and it's going to grow. Hopefully, it's going to grow and grow and grow.
Right.
And so then that
And then
could
it's
have been
going
worth,
to the heirs,
and then it's-
which is
yes.
probably where to go anyway.
Yes. And then you can still live there after the term. You'd be paying rent to your kids if they're the beneficiaries. So I mean, there's you can still use it, but you don't own it anymore. And then there's some other negative consequences. The step up in basis. If I leave something to somebody, then they inherit it at the value of it on my date of death. If you do a CUPRT, they are going to lose that step up.
Let's say you built that house
Yeah.
for $300,000
Yeah.
and it's now worth $1 million.
Yeah.
You gift it to this trust for
Mhm.
$500,000.
Mhm.
If you would have had it in your estate,
Yeah.
you would have had an asset worth $1 million that gets a step up. The $300,000 would get stepped up to $1 million, but
Mhm.
now that $300,000 cost basis stays
on that,
with it.
Yeah. So then if they're
So
like,
it's
I don't
ever
even want this and
sold,
you're gone, I'm going to sell it. Well,
It's gonna be a
listen,
gain
yeah. So
when they sell it.
again, you got to make all of these things. First of all, you may not outlive the term. If you die before the end of the term, the whole thing's it's unwound,
Evaporates.
and it's like I didn't even do this. So all of the tax benefit that you lose it, right? As with anything, you have the info, and you got to give your best guess as to if I think this is going to be right for me. And you could put
So
half
is
of it in a
this-
5-year term and half of it in a 20-year term if you want to kind of hedge
that.
your bet.
So the last couple of trusts we're going to talk about is the first one is a grantor retained annuity trust. That's again reducing estate taxes.
Yeah, it's basically it's somewhat similar to the concept in a charitable remainder trust where you're getting an income stream, for a set amount of time, and then at the end of that term, then the assets would go to the beneficiaries that you listed. For a CUPRT,
So it's not going to a charity though.
No,
it's
no,
going
it's
to
not.
beneficiaries you
Yes,
listed.
yes.
So the idea is you can put something maybe like an asset that's going to grow.
Yes, exactly.
Get it out of your state.
Yes,
You can get an income from it.
Correct.
And then it's going to pass the beneficiaries outside of your state.
Correct. Basically, the CUPRT that we were talking about earlier, if you sell the home while it's in a CUPRT, it basically turns into a GRAT. It turns because then it becomes another asset that's treated like an annuity.
Got it.
You're getting the income stream, and then it passes to an immediate gift tax benefit that you're getting a discounted gift.
Got it.
So that's what that is.
And then the last one is a life insurance trust, also known
Yes.
as an ILIT, because it's an irrevocable life insurance
Correct.
trust.
Yes.
I've seen a
Yeah.
lot of these in my career.
Yes.
Because the estate tax, to your point, was
Mhm.
really low. The state tax exemption, that 14 million we have now, was really, really low 28 years ago when I
Mhm.
started in the
Mhm.
industry. It
That's
was
right.
less than $1 million.
That's right. And a lot of times, the proceeds from a life insurance policy, that counts towards your estate. Many people don't think about this when they think of their net worth. I mean, it's not your net worth, but for estate tax purposes, your taxable estate is going to count the proceeds of a life insurance policy.
So if you pass away and you have $1 million in life insurance, that's going to be counted towards the 14 million.
Correct.
Is what you're saying.
Correct. So a way to get that out of your estate, you can create an irrevocable trust. It's called a life insurance trust. That the trust is the owner and the beneficiary of that policy. Of
the policy on you.
Yes.
So in the case of
yes.
Yes.
And the benefit is you're reducing the value of your taxable estate because those proceeds are kept out of your estate. Now, a con to this is there's administration that is required. There are these things you may have heard called crummy letters, and it's called crummy from a court case. But basically, you have to give notice to the beneficiaries that they have a right to withdraw a present gift. It's administration that is required.
So basically what is set up, it's really strange. I've seen these, but it's very strange. So it's like you have this trust and it's titled as a trust, and you have an account that's in the name of the trust. And the premium payments for the life insurance go in there each year. Yep. They have to sit there for a certain period of time. The crummy letters go to the beneficiaries and say, hey, we just made a gift because those premium payments to that future beneficiary goes towards their annual gift exclusion. So it's like, okay, I just made a gift. You have the right to withdraw it if you want. You don't want them to. And then obviously, you pay the premium through that account to the life insurance each year. So that's the way that and so every year you have to do this, where you have to fund the trust to then pay the premium payments and then send the notices, not in that order. Send the notices first and then pay the premiums. So, and you have to keep these letters. Yeah, you have to, it's good to keep them in your records, because if there's ever an audit, then having that, you don't have to sweat it, right? If you don't have them, it's going to create a bigger headache. But you could imagine years ago when the exemption was only $1 million. Oh, that's why. So many people had $1 million, and then you'd have life insurance on top of that. And it's like, okay, well then if we set up this irrevocable life insurance trust, and then the life insurance policy gets paid there, then it's not included in my estate tax calculation. But since the exemption's so high now, they're not used very much. I haven't set one up in years. Not as much as they used to before. I think one of the reasons why they, in addition to the immediate, estate tax protection that you get from it, is a lot of these irrevocable trusts, you're giving up control, right? But for a life insurance proceed, you're not really thinking about it like that, because it doesn't exist when you're alive, right? The benefit doesn't. So in a way, what am I really giving up control of? I'm not giving up, but again, it's the administration. Do you know what I've seen before? I've seen where you have a family that, someone, maybe like the parents set this up and it's for the benefit of the children later. And then they're spending down all of their assets because they're living longer, right? Which, so they're spending down a lot of their assets. They may have this life insurance trust that's going to be funded and paid out. Well, then maybe one of the kids went astray. So it's kind of like, well, we don't want to leave them as a beneficiary. You can't undo that whole thing. You can, but it's a messy. Yes, exactly. I was going to say it's unwinding a lot of the only thing where these trusts, where a revocable living trust, very, very flexible. Changing almost anything else that we've talked about in any of these other trust vehicles, it's while it may be easier now than it was a few years ago, it's still time, money, stress. Yeah. So really, before you fund them is when you have to really make sure that you know what you're doing. Creating these trusts, you're never done once you create the trust. You have to fund, maintain, always check in. So these are vehicles that provide many, many benefits, but just like everything, just like your finances, you got to keep up with it. So good. Thank you so much for going through all of these. If you have questions, you can always reach out to us or reach out to Arun as well. We have some other podcasts referenced in the show notes. Episode 295, What Happens If You Die Without a Will. I think you and I did that one, actually. Episode 279, What Should Parents of Children with Disabilities Know About Estate Planning? Episode 233, How Second Marriages and Blended Families Impact Estate Planning. We have a couple other education videos in there. And then, of course, we have a link to your website if you want to reach out to Arun. He's extremely knowledgeable, does, free consultations just to talk about a situation or see if something's a good fit for you. But thank you for coming again. I'm sure we'll have you again. It's always a pleasure working with you. Thanks for listening to today's episode. If you're interested in learning more about Wiser Wealth Management or would like to schedule a consultation to meet with our fiduciary financial advisors, you can do so by going to wiserinvestor.com or by clicking the link in the episode notes. We'll see you next week.